At the last meeting, this came up, and we had said we would defer until February, because I didn't have enough really time to put into it. But there have been a number of things going on. One of the main ones was Sierra coming back, but also some related projects. So we sort of started digging into it more, and I just wanted to take this opportunity to sort of give you guys a, sort of a progress report of what's been going on. And this is the adjudication right here. This is one of the original documents, one of the decrees from the Superior Court. But the related effort that's going on is the Resource Conservation District. The Resource Conservation District has a grant from the Wildlife Conservation Board to look at alternatives to surface diversion on Soquel Creek and encourage folks to not divert water, particularly not divert water during critical periods, and in order to leave more water in the stream. So we've been working with the RCD on that as well, and they've been working with Trout Unlimited. They've established some stream gauges for the last 2 summers in various parts of the Soquel Creek watershed to measure flow. And they sent out something like 1,400 postcards and invited property owners to come to a meeting last Wednesday, when it was pouring rain. Probably about 40 people showed up.
Oh, that's cool.
And it was a good meeting. It was a group of folks that you don't normally see at these meetings. We also had the attorney from Trout Unlimited come and give a presentation on overall water rights and how water rights work and what some of the different obligations were. And it was a pretty positive meeting. People were very interested to get the information. And Trout Unlimited and the RCD are going to move on towards different recommendations for things that people can do to reduce their diversions. So the RCD has taken the adjudication and basically has digitized the whole thing. So there's an Excel spreadsheet that lists all the diverters, and they also put all the points of diversion on the GIS map. So we do have better mapped information related to the adjudication. And then Sierra's also been working with that. There was a handout that went around, and on the back side of it, it shows all the various points of diversion that are recognized in the adjudication. It's something like, there's 244 first priority users recognized and 161 second priority users recognized. The interesting thing is, when we go out and walk the stream, we're seeing very few active diversions at this point. So a lot of these people are recognized in the adjudication, but they are not exercising their rights, which is good for this stream. Because, for instance, the first priority of everybody with a first priority was taking water out. That would be a total of 0.35 cubic feet per second.
And that's mostly riparians?
Yeah, the first and second priority are riparians. The third priorities are appropriative rights. There's 17 appropriate permits. But the second priority rights add up to 2.57 cubic feet per second. That's for irrigation.
This adds up per their reports to the state board, or
no,
somewhere?
Just in terms of what's in what they're allocated.
Oh, okay.
The allocations add up to that amount. So it's a pretty huge amount of water.
Well, City of Scotts Valley is allowed to take 14, right?
Well, this does include City of Scotts Valley, because that's an appropriate.
That's a tier 3.
That's a tier 3.
Yeah.
And they're not included in this, because that's on the order of thousands of acre feet.
Right.
For the Glenwood Reservoir project. So we're sort of ignoring the 2 reservoir proposals and reservations in the watershed, and just looking at sort of the direct diversions or the diversions to small storage. But when you compare that to the median flow in September, it's only 2.2 CFS. So, as is often the case, it's over allocated. under the adjudication. The city of Capitola, who actually initiated the adjudication, they have an allocation of 3 cubic feet per second at the lagoon. So they're down at the bottom of the watershed, but they're all third priority, so they don't necessarily get that.
And there's no provision for, there's no floor to maintain beneficial uses?
There is no floor to maintain beneficial uses. The only requirement is that there be visible flow at the lower end of each stream reach that's been allocated. So it could be a trickle. So there's no reservation, there's no environmental flows, there's no, public trust flows. This was all before the Mona Lake decision, so there was no real consideration of that. But again, and in terms of actual impacts on the stream, we saw the stream go dry in both 1992 and 1994 for up to 30 or 45 days. At the USGS gauge on Main Street, the stream went dry at that location. The good news is since then it has only gone dry for 15 minutes during the last drought in September. So I think that there are a lot fewer people diverting than there used to be, because we have some records of fishing and wildlife surveys where they went along the creek and mapped diversions. Kristen and I went out during the drought in 2013 on the main stem, and we saw 5 active diversions in the whole distance from SoCal all the way up to, well, not all the way up to the confluence, but up to Casalegnos, up to Moore's Gulch. And then she walked the East Branch just this fall, and there were only 2 active diversions on the East Branch. So the good news is there's not a lot of active diversion right now. The bad news is if they did exercise those, there would be some substantial impacts on the creek. So one of the things that Trout Unlimited, they've done a lot of work up in the North Coast and some of those streams up there, encouraging people to develop summertime storage, divert during the winter to storage, and then have a big enough pond or tank to get them through the summer without diverting. So that was sort of their approach going into this. And another option is to use wells. Pretty much all of these folks with surface water rights also have wells, and the couple of people, when we did the survey back in 2013, I sent letters to all the diverters that we observed and reminding them of their obligations under, to report their diversion and filing a statement of use, and also to get their fish and wildlife permit as well. Several people called me back and said, I didn't realize what the issue was, I'll turn off my diversion and switch to a well. Although the other night, one of the guys that I sent a letter to said, well, can I use my stream diversion now? Is there enough flow?
Well, to me, that's one of the issues, is there hasn't really been an in-stream flow study, so we don't really know what the standards ought to be.
Well, yeah, and I guess I'm not real, yeah. I mean, in-stream flow studies are expensive, and I'm not sure how much information they give you.
Well, our whole water supply planning process is based on in-stream flow
Right.
studies, so.
You guys have a lot more money.
Right.
Yeah.
But, I mean, I think, and obviously money has to be part of the consideration.
Yeah.
But that's why I said, if we decide to do anything with this, these are the things that I saw. It was obvious the amounts of water didn't add up. It was obvious there's no reservation for environmental flows. There's no appointed water master or special master. And maybe those are reasons to abandon the original adjudication and just say, it's good enough as it is and we'll figure it out some other way. On the other hand, the feds did say in the co-recovery plan that a fee structure ought to be established to appoint a water master and that the adjudication ought to be implemented. So it just felt like from a water commission perspective, we needed to at least do some housekeeping on, are we doing anything with the adjudication or not? And if we're not, let's make a conscious decision rather than just not dealing with it.
This is one of the things that might happen if we, proceeded with trying to do something with it and, ask the courts to levy fees on the users. We might see a lot of the users abandoning their rights too, instead of paying a fee, which wouldn't be a bad So, I don't know, Sierra, do you want to add anything? You put together sort of your fact sheet
Yeah.
going through there.
So this is not a history of the adjudication, this is just kind of a summary of some of the key points that were in the adjudication document, because it is quite long and really there's not that much. There's a few things that are particularly pertinent, so I put them together in a one-pager. It's on the other side of the map. The only thing that I can tell that no longer applies when this was written, this was done in 1977. The original order that this was based on was done in 1975 by the State Water Resources Control Board, and they had actually proposed four priorities of water rights, the fourth one being riparian adjacent properties that didn't apply during the original adjudication process for their allocation. They had suggested that those folks would be a fourth priority. In this adjudication, they were deemed to be the same as a first priority. They just basically needed to notify someone that they wanted to use their riparian rights. And then case law changed subsequent to this in 1979. And that basically states that no, those non-using riparian owners no longer share an equal footing with riparian owners, but I don't actually know if that makes them like a fourth priority, or if that makes them a third priority, or if they just don't get any priority at all. That wasn't clear to me, but.
It's interesting that they said that unexercised riparian rights have to go back to the court
Yeah.
to basically find out what's left over for you. Usually riparian rights are given first priority.
It basically implied that you just needed to notify them that you were going to be using them.
Oh, okay, it's not like a consultation, it's just notifying them.
Yeah, I think it was just notifying the state board. Anyway, that's kind of a moot point because it no longer applies.
So they would have to go back to the court if they wanted.
If they wanted any rights, yeah, because right now they essentially have none.
And the first priority rights are for domestic use, pretty much, essentially 500 gallons per day, which could be cut to 250 gallons per day during periods of limited flow.
Right.
And then the second priority rights are often on top of those domestic use rights for irrigation use. And that's why the volume of the second priority adds up to so much more than the first priority.
Has the county permitted any building where they're getting their water supply from the creek, or are they all wells mostly?
They are all wells. We have had a few instances where somebody has proposed a stream diversion as a source of water, and this is one case where the adjudication is used. I will look up whether or not they actually have a recognized right to that water. Most of the time they did not, so we said no, they can't use a stream diversion for building permit purposes. But that's probably come up 2 or 3 times at the most since I've been here.
Yeah. I wonder if we want to give folks from the public a chance to speak to this before we figure out what we're going to do, if anything. Any comments or questions over here? So, Becky?
I have a question about how this affects the wells very close to Soquel Creek that are owned and operated by Soquel Creek Water District. Chairman Daniels has said that when they turned off the Main Street and O'Neill Ranch wells, they saw rapid increase in flows in the creek within 10 days. And so how do wells that affect the stream flow tie in with this? And maybe that is a question that goes back to there's no base flow, so we need to do that.
There's a lot of questions around that. But one is, are those wells considered groundwater under the influence of surface water? I don't even know.
No.
They're not.
And I should say more about that. I should have said more about that. I mean, the other thing that's going on in this whole process is the Sustainable Groundwater Management Plan and developing the Groundwater Sustainability Plan, where we have a surface water working group that's looking at the extent to which groundwater extractions are affecting stream flow and putting measures in the groundwater plan to keep any effect of groundwater extraction from causing adverse impacts on surface water uses. So that process is going on. I have yet to see the data that Dr. Daniels has referred to. There has been some subsequent work looking at the O'Neill Ranch well, and it does not seem to have any impact on flow. The hydrologists haven't been able to identify any impact on stream flow. The Main Street well is another story. We have not been able to quantify direct impact from the Main Street well over the years, but it definitely seems to have more of a longer-term effect. I mean, the issue, if a well is directly drawing from, well, either drawing water directly from the stream channel, or if the groundwater is flowing through a known and definite channel, then that is regulated can be regulated as a surface water diversion under state water law. But that does not seem to be the case here. What we're a little more concerned about potentially are some of the smaller private wells that may be drawing from alluvial areas in close proximity to the creek, where you may have a channel cut into the underlying bedrock, and then there's just alluvium in that bedrock with the stream flowing through it. Those wells are going to have a much more immediate effect on stream flow. They're almost, I mean, that essentially would come under that would come into the jurisdiction of the State Water Board as a surface water extraction.
So that's like Walla and Carmel, I'm sure.
Yeah.
Where you have basically a channel of alluvium.
Right. But for instance, the Main Street well, it's, I forget how deep it is, but it's hundreds of feet deep, and it's drawing from much deeper aquifer layers than, it's drawing from the AA and the TU unit, not drawing so much from the A unit, which is where the stream is. But I think regionally it does have an effect, and when it definitely seems to have an effect on the shallow groundwater as well as the deeper groundwater. You can see some of that when you turn it on and off. But I would like to get more information from what Bruce Daniels talks about, because the hydrologists have, we've been spending a lot of time looking at the Main Street well, trying to figure out how much effect it has, and it's not clear cut. And we're still working with the groundwater modelers to get a better modeling of the relationship between the groundwater that's in the alluvium and the groundwater that's in the deeper aquifers, and how that's affecting the stream flow. They're still working on trying to get the model to give us better information on that, and then we will go back in and do the groundwater piece of the maintaining stream flow. So we're sort of coming at this from two sides, both the surface diversion side and the groundwater side.
Which is good. We didn't have the Sustainable Groundwater Management Act back in 1975.
Hey, John, is there any active agricultural diversions in Soquel Creek?
It does not appear that there are right now. There were in the past.
Right.
And there were nurseries up there. There were active agricultural diversions. The ag users in the nurseries are now all using wells. There's some big pastures, irrigated pastures. I've spoken with them, and even though they have a surface water right, they said they're using their wells. And that was what we saw when we didn't see any active diversions. Everett Family Farm is another big agricultural operation up there, and they use a well.
What about cannabis?
Cannabis, I would suspect there are cannabis users using surface water in the upper watershed. In fact,
Unlicensed.
Unlicensed.
Yeah.
I mean, we
Their time is
had
coming.
realtors up there that were advertising that they have water available from springs.
You see that all the time. There's some
I
notorious
actually
realtors.
contacted one of the realtors and said, no, this property does not have legal access to any kind of surface water because they're not recognizing adjudication.
Right.
But if you look at the map, there's this cluster of water right, first priority rights up in one of the tributaries up in the watershed. It's pretty interesting.
I bet if Rich Sampson were here, he would say, oh yeah, we know that neighborhood well.
Yeah, yeah. So I think the cannabis users probably have an impact more up in the upper watershed. The East Branch definitely seems to have more impact. The East Branch does go dry. In the last drought it went dry. And there's you know, it's interesting because there'll be flow upstream in the East Branch, but then when you get down to the mouth, it's often dry. I found some old data that the county did in 1994 during that drought period when the creek was dry down in town. Upstream at Moore's Gulch, the flow was 1.25 cubic feet per second, so it was losing that much flow between, you know, as it flowed down through Soquel Valley. And it's been identified as during dry periods as a losing reach by a number of investigators through there. And again, that's probably mostly groundwater extraction, but in 1994, there were a number of active surface diversions in that reach also, including for some of the nurseries. So it's an issue that I think was more significant in the past than it is now, but it's still something that we need to be looking at.
Yeah, it seems like it's a good opportunity now with the MGA to sort of get a holistic approach toward managing the basin, and this is certainly a part of it that's been outstanding for decades.
Yeah.
Either that or we need to decide it's so unimportant that let's just forget about it. But it seems like isn't it the only adjudicated basin in the county? Yeah. And it seems like they kind of stopped halfway, and Judge Hodge helped me out with your experience. But I think when you read the adjudication, you were like, well, they reserved jurisdiction, that's good, and they protected those unused riparian rights, but they didn't really finish the job. There's no water master, there's no fee structure, so it really doesn't have too much standing at this point.
I learned more today sitting here than I did from reading Judge Craig's a great deal more. Reading it in the abstract wasn't very helpful.
Yeah.
And John was asking me questions about process, just as you did now. We've got these problems coming up. What are we going to do? What's the way in terms of process to deal with it? And I read the opinion. I was fascinated by it. I'm very proud of my American River case. I could spend the rest of the day talking about it. Judges don't get these cases very often, and I was the only one in Alameda County who volunteered on the bench to say, yeah, I'll take that case. Because I knew some people who were working on the Carmel River as hydrologists and whatnot, and so I said, well, I wanted to figure out what they're talking about. And the opinion, I'll take 2 minutes on it, the opinion does not have precedential value in the sense that it never went up to the Court of Appeal. It had been in litigation for 20 years before it got to me for trial. I went to the California Supreme Court twice, U.S. Supreme Court once, went to the State Water Resources Control Board. And when I expressed my concern about being so uninformed about water, the lawyer said, don't worry about it, Judge, no matter what you do, it's just going to go up on appeal again. So you're going to be finding facts. And I took that as a challenge. I wrote this 100-page opinion, and all of the parties, all the stakeholders in the litigation, I wrote a preliminary opinion to say, what do you think about this before I wrote a final one? And everyone said, we'll live with it. So it didn't go up. So basically, this person here who knows nothing about what you're talking about around the table, I basically ran the American River for about 10 years, in the sense that the essence of the opinion was, look, you guys have litigated for 20 years, you haven't answered the questions about the management of the river. You've had positions here, positions there, who's got the burden of proof here, who's got the burden of proof there, but you really haven't answered the questions. So based upon the evidence I've got now, I'm going to enunciate flow patterns appropriate to the river. And then, and this was a critical part of it, I implemented a totally novel procedural process by which the parties had the opportunity to do continuing research under my guidance, really the guidance of the special master, John Williams, who was on the Carmel River case as well. And so what the process then was, these are the flow patterns. They're called the Hodge flows. All the rivers in Northern California run, maybe you've seen hydrology reports, they run on the Hodge flows. And basically I said, these are the state constitutionally mandated flow patterns. Now, if there's evidence that develops that would indicate they should be changed, well, then we'll have a hearing, and if appropriate, I'll change it. But everything was done under one aegis. We didn't have to wait for somebody out in the boonies to come up with a new lawsuit filing with a lot of trying to get in on the action. Everything was already there, and we had the process for doing it. It was as much legislation as it was litigation. And I've been a number of law reviews written about it, and again, I'm very proud of it because it was novel, and novelty has not been a trademark of my experience in the law. So, John asked me about process, and he indicated, and I may get this wrong, John, bear with me.
Chris.
Indicated that, we started talking about San Lorenzo River, just informally, and he's talking about coho salmon, and of course, the critical issue in the American River is what are the flow patterns? The threshold question, I'm just about done. Threshold question was, could East Bay mud divert 150,000 acre feet of water at the Folsom Dam, or did they first have to let it flow down the American River into the Delta and divert from there? And back at that time, carcinogenic issues were real, and diverting from the Delta was a problem, and then you had all the environmental problems, particularly the salmon. And so what flow patterns are required to protect the salmon, but still give appropriate rights to East Bay mud? That's really simplification. But when John told me the problems of Soquel Creek, I said, yeah, that was my problem. What's the water that's required to protect the Chinook salmon? And the way I understood the problems that John was presenting to me was on the San Lorenzo River, what's happening to the coho salmon, and what water flows are required to protect the coho salmon. And the creek, Soquel Creek, is part of that issue. So my first response listening to this here was, okay, what is your threshold problem that you're trying to address? If the threshold problem is we have a fishery here that needs protection, and the Soquel Creek is part of it, and we have no control right now over the diversions. We have no way of regulating what's going on or even knowledge about what's going on. And so what do we do about that? That's the way I understood the question you were posing for me, John. Maybe that's wrong. Okay.
Well, we're protecting multiple beneficial uses, I think, both diverters and stream flows for fish.
Yeah, that's true. But same issues we had in the American River.
Yeah.
And so I looked at the Franich's opinion, and I kind of marveled at it in the sense that here in 1974, and now my suggestion to John was, look, just as when I reserved jurisdiction, I had control over it ad infinitum, so Judge Franich, who represents the Superior Court now, had control over this group of problems, and he left it completely open. As you noted when you did your presentation, he reserved jurisdiction to adjudicate any issues with respect to riparian owners or essentially anyone else.
Yeah.
In other words, the way I understood it, from his perspective, if you got a problem with whatever the diversions are on Soquel Creek, just file a petition, and then what the judge would probably do would be refer it to the board, get an opinion from them, and then decide if you want to follow it or not. But that would be the process, and it would be greatly simplified rather than, for example, having to start all over. I don't know what you'd do if you decided that you wanted to say, okay, we want certainty right now as to who can divert what water, what time, under what circumstances. I don't know who would bring the action. I don't know what would happen, but you don't have to worry about it because the action's already there. And you also hit on a key point. A couple key points that were in the back of my mind. The fact is, when the Soquel Creek decision was written, the Mono Lake case had not been decided, and the public trust doctrine basically didn't exist in California. I mean, it did, but it was dead. And so the scope of issues that would be before the judge if we went back into Santa Cruz Superior Court would be greatly expanded by the imposition of public trust considerations. Because if you're talking about public trust, these diversions, comparing one against the other, that's a very small part of it.
Yeah.
The question is whether collectively those diversions are going to be an impediment to spawning of the cove, salmon, etc.
Right.
And so the question is, and I was interested in you saying, well, no one seems to be having any problem, they don't seem to be over-diverting, everything's fine. So you got to start back and decide what's your objective. If you know, if science has told you what the flow patterns are needed for Coho, for SoCal and San Lorenzo River, and if you can make your estimates about what the diversions up on Soquel Creek are doing with respect to those objectives, then that's your starting point. And then you can say, well, you can't divert that much water, or fine, divert, or fine, divert until you reach certain standards and you can't divert anymore.
Right.
So, I don't know, it's an I don't know that that's helpful at all, but I'm just saying it's useful to have that decision there. I was fascinated by the fact that the lawyer for the Water Resources Control Board was named William Atwater, and what else could he have done with his life?
We work with a biologist out at the Southwest Fisheries Science Center whose name is Heidi Fish, too. It's like, what else could you be but a fisheries biologist?
What else can you do?
Yeah. Well, thank you for that. I think
Was that helpful at all, John? And did I miscite the way your approach to me on this? You were shaking your head no.
That's
so.
more or less it. I think
Yeah.
where we're at, though, is like, do we revisit it from the ground up, or do we say this is good enough with some tweaks or something else? And frankly, I wrote an email to a couple commissioners and John prior to the meeting, and I said, these are the issues that I think need to be addressed with the adjudication, and most of them you just mentioned much more eloquently than I did. And I said, I think we ought to just ask the board to ask the MGA to look at these issues as they're doing the groundwater management planning, because it's part of that process on some level. You know, if they're looking at basin-wide issues, this would be a natural, you know, if you're looking at groundwater dependent ecosystems, for instance, you could get at that, what are the fundamental base flows we need to protect those beneficial uses? So rather than us trying to weed through each and every individual facet of this document, you know, it might be more appropriate to have the MGA look at it, not to pass the buck, but
Right,
because it's part of the
MGA
ongoing
has no
work.
authority over surface water diversions. Their authority derives from Sigma, so they have authority over groundwater extraction, not surface water extraction.
Okay.
So
Well, I thought I was teeing off of something you said at the last meeting by going that direction, so perhaps I misunderstood.
well, the MGA is looking at they're looking at the issue of flow to some extent, but they're really, we kind of narrowed it down, and when you talk about the MGA, it's basically Sierra and I and the hydrologists are doing the staff work on this right now, and realizing that some of the limitations that we're dealing with in terms of so many other factors affecting flow besides just groundwater, we're really trying to narrow it down and say, okay, we're going to focus on groundwater, we're going to focus on groundwater adjacent to the creek to maintain those levels at a point where the groundwater is continuing to contribute to flow.
Yeah, I would think groundwater users would want to have some certainty that there's some rigor in the implementation of the adjudication too, though, so they don't bear the burden of there not being adequate implementation of the adjudication.
Well, it's interesting because most of the surface diverters are also groundwater extractors.
So they're fighting with themselves?
Yeah. So, I mean, one of the first recommendations I have for them is don't use your surface diversions, use your wells instead.
Yeah.
Because any impact is going to be greatly attenuated, if not mitigated, by drawing from groundwater, rather than pumping directly out of the stream. But then we still get back to, okay, what's the impact of that groundwater pumping on the streams, which we're still trying to get our handle on.
I was wondering if I asked the judge, how expensive is an adjudication from beginning to end?
How much do you have?
Especially if you gotta start over.
Well, how much? gee, it's enormously expensive. First of all, water lawyers are the best lawyers in any discipline in the
We
state.
pay $535 an hour to our water rights attorney.
He's too cheap, that's not very much money.
Well, I'll tell him. No,
No, it's very expensive, and I was thinking, and if you let this, and I should, the strategy, this is not, you know, that's not what I'm here for, but I was listening to this, and I was thinking, it's sleeping dogs lie. If you don't have a problem, do you want to open it up and invite these people in to start then fighting over their water rights, and then maybe taking positions that they might not otherwise take? And it would be, litigation-wise, it could be an enormous venture for everybody, and I just don't know. In fact, I was going to add, you seem to have a handle on this, Sierra. Do you know what was the motivating factor, or who were the interested parties that got this thing started?
Yeah, so it started in 1972. It was actually the city of Capitola. They had noticed that there had been a big spike in diversions upstream, so the lagoon wasn't filling up as much, and they weren't able to make sure they had adequate supply for recreation and for fire protection. So they're the ones who petitioned the Superior Court initially to do this adjudication, and they ended up, they only have third priority rights in this, so I don't know that it worked out for them.
Well, it's interesting though, because unbeknownst to a lot of folks, the lagoon in Capitola is not just for fish.
Right.
You know, they were using it for recreation and for firefighting.
Yeah, they said recreation and firefighting was
Yeah, those were the two.
beneficial uses that they
Yeah.
identified.
And funds.
And actually, there is a requirement in the adjudication. The only time fish are actually mentioned is just saying that between May 1st and May 30th, they have to allow the city of Capitola allows a bypass through the flume of at least 1 CFS or natural flow, whichever is smallest. That's only mention of fish in the whole thing.
So were there a lot of people that came to the table when that litigation came about?
I would imagine you can see from this map the number of,
There is a long list.
260.
yeah.
Yeah.
Yeah, I mean, I don't think we want to kick the dog if there's not good cause for kicking the dog, but we also, it's sort of a big thing to have left undone.
Yeah.
Yeah, I mean, one of the things that we have been doing at the county, and we could potentially do it more, is work with, particularly if we had, you know, sort of the cooperation of the resource agencies, is put people on notice when they're, you know, when we do see diversions, to let them know what the requirements are for maintaining a diversion, because there are more requirements now than there were back in 1977. They're all supposed to have their lake and stream bed alteration permit from Fish and Wildlife, which Fish and Wildlife can actually put conditions on that permit over and above what's in the adjudication.
Right.
You know, we could approach it that way if, you know, since maybe it's not so much of a large systematic issue, but more an issue of individual diverters, similar to what we see in San Lorenzo where there's not an adjudication.
Right, and similar to what's going on with the cannabis ordinance, where there's some provisions in there for diversion that are above and beyond what water rights might require as they stand now.
Yeah, well, as an example, we have a property in San Lorenzo that wants to use the stream as a water source for their development up in Newell Creek.
Oh, yeah.
And Fish and Wildlife has the condition on their permit is that they have to develop storage tanks so that they don't divert during the summertime, that they can only divert during the winter and spring, and that they would cease diversion during the summertime, even though under water rights law, they have a riparian right to divert year-round.
Yeah, I think that landowner agreed because they built their house without permits 30 years ago. And they are facing, you know, conceivably, a worst case, it could be abatement, like you just can't live here anymore. But if we were able to do more of that, that might be more effective than revisiting the adjudication.
And more cost effective too.
Mm-hmm.
Is there any science on the impact of these cumulative diversions on the salmon, on the coho salmon and so on?
So that's the one of the things we keep
at.
getting at, is we don't have the science to begin with to say what the effect is.
Yeah.
That's why National Marine Fisheries and the coho recovery plan said we need to have a fee structure to support a water master, and we need to develop better understanding of what the flow needs are.
Because that was, again, the essence of American River. We had science on the flow patterns required to protect the salmon, and that was the issue.
Right. I think DFW is putting these conditions on the streambed alteration agreements because they know that if they require in-stream flow studies, it'll be a protracted process and they maybe won't get what they need. So they figure, well, at least if we protect the most critical life stage, which is rearing in the summertime, then we're getting 90% of what we need.
Yeah. They
So
also
it's sort of
seem
a
to
cost
be,
benefit.
they seem to be getting away from the on-the-ground in-stream flow studies to going to more of a desktop calculation of,
DFW is because they're having to do so much of it.
you know,
Yeah.
they looking at what the average annual flows are and then saying, okay, we want to reserve a certain percentage of that for the fish.
And looking at basin size and that kind of
Yeah.
stuff too.
I mean, when you do the in-stream flow studies, I mean, what you find out is that the natural flows are way less than optimal. So then you're back into saying, okay, well, how much are we gonna protect or what percent are we gonna keep?
Not only that, in a couple cases with the city's in-stream flows, we find that with diversion, we actually have better conditions for coho than without.
Really?
Because coho like lower velocities.
Uh,
So in super wet years, there are some habitats that have velocities that are too high for coho,
Interesting.
and we reduce them by virtue of diverting the water.
Now, is that just during the spring?
You know, I think it's a winter-spring thing, you
Yeah.
know. It's
It's
certainly
one of the
not.
interesting things that we did, and we did endless research projects over these 10 years to decide optimum temperatures and this and that and everything. And one of the stark findings was that the Chinook salmon actually didn't need the water to be as cool as everyone thought for 20 years.
Mm.
It didn't matter that much, and
Yeah,
and
yeah.
flow paths were not modified, but that was interesting. So that's
Yeah.
that's the reason I say, where are you starting with your question? If the question is, we need X amount of water for the coho, then you go to, okay, how do we get it? And does
They're
that
still
mean-
trying to figure out what questions to ask.
Yeah.
That's where we're at.
Yeah, yeah.
I have a question for you, Judge. So one of the things in this adjudication, it says that allotments of water contained in this decree shall not be used in an area or in a manner contrary to, among other things, county ordinances.
Well, the real issue is gonna be public trust and Article 10, Section 2 of the Constitution, which is the optimum use, most beneficial use of water. I forget the magic terms, but that is the criterion, and you work backwards from that.
Yeah.
So there's a lot of stuff in here, it's just arcane. I mean,
Right.
how could you have even done this without reference to public trust? I don't even know, but that wasn't the issue at the time, and he didn't do it, and he didn't have him on our lake, so.
That's an interesting point though, because conceivably the county could sort of do an end run on the
Yeah, like
whole
a
thing
workaround.
and just create an ordinance that says,
Yeah.
thou shalt not divert below 2 CFS.
Yeah, that was exactly my line of thinking there, was just, if we had a county ordinance that protected stream flows of a certain amount in the creek, if we're allowed to do that, then.
I think Linda would like to make that motion right now.
You do make
And there's also, in the
recommendations.
very beginning, it says that a claimant cannot exercise his rights in such a manner as to unreasonably impair the quality of the natural flow.
Yeah.
And so between, I don't really know
Judge
how to
Francis didn't know
define,
that, but essentially he was quoting Article
Yeah.
10, Section 2.
Yeah.
of the
so
Constitution.
whatever
Article 10,
we
Section
consider
2.
reasonable, can we make an
Well, you have to
ordinance about
litigate
that?
on reasonable. I mean, it's
Okay.
subject to interpretation, right?
Oh, yeah,
Yeah.
So,
just like what is negligence? What
right.
is reasonable?
But yeah, those were the things that kind of jumped out at me as maybe an easier way to deal with this than opening Pandora's box.
So one of the things we could do, I mean, we could continue the discussion, and we don't necessarily have to decide anything today, but as we better define the approach that we're doing under Sigma, we could, this commission, we can report back to the commission and continue to think about, well, what do we want to do on the surface diversion side to complement what we're doing on the Sigma side.
It's a good idea. I don't think we want to rush to make a decision today. I mean, it seems like the more you dig into this, the more you learn, so it would be unfortunate to open that Pandora's box without fully thinking about it.
I didn't mention, I did email the State Water Resources Control Board, the Division of Water Rights, and I just asked them if they had any thoughts on this, so we'll see if somebody gets back to me.
Ask them what they thought about the American River Cave. mistakes. Because I basically didn't follow very much of what they put in the Declaration.
Becky, you have a question?
I do. I have a couple of questions because I really think it's important to make sure this issue is cleared up as Sigma moves along in terms of, stream flows can be defined in the plan as some of the undesirable gauges, or I forget the term, that is related to the groundwater. So the stream flows are important for the Sigma plan. And my thought in listening to private well owners along the creek who have essentially gone to using their wells instead of the riparian rights is down the road in the future, if there becomes some high fees or what people think are unreasonable fees, they may, for private wells, they may abandon their wells and go back to using the riparian rights.
Yeah.
So I think because of that, it's also very important to get this cleared up.
Yeah, I don't think we can count on